Welcome to Sherloc Exposes. My name is R.C. Williams. This is Episode 2, U.S. Government Exposed, U.S. versus Randall Crater, Bellwether Crypto Case, Lies, Omissions, Intimidation, U.S. versus Crater, U.S. District Court, District of Massachusetts, number 19-CR-10063. In this expose, we look into corruption, collusion, and conspiracy between the Department of Justice, the DOJ, the Securities and Exchange Commission, the SEC, the FBI, the Federal Bureau of Investigation, and the agency, the Commodity Futures and Trading Commission, or the cftc, in a bellwether case for cryptocurrency against Randall Crater. If you missed part 1 of our expose or any of our prior press releases, you can find that information and links to all the whistleblower documentation that we have at Sherloc, that's SHERLOC.substack.com. That's Sherloc.substack.com. Let's get into part 2 of our expose. A breakdown of government methods. In part 1 of our expose, we looked at the statement from the DOJ on the U.S. versus Randall Crater case and broke down the statement for very specific reasons. A well-worn technique of government agencies is to utilize the quote-unquote wrap-up smear, also known as character assassination, of a target regardless of the actual circumstances, and to weaponize an endless amount of press releases and media outlets who will willingly quote-unquote run with the story as is. By doing so, government agencies gain a false high ground that's powered by accusations without all the facts. And once the accusations are out, regardless of whether they're true or not, they are used over and over again. As you'll hear in a moment, even though the cftc was unable to prove the primary allegations they've used over and over again, they continue to use them to push their narrative. Often our human nature in a bite-sized world of news and information is to take headlines and accusations as fact first. Then, if we're so moved, we'll dig deeper to see if evidence is available to the contrary. Once fully weaponized, the government can then begin the process of squeezing by the use of grand juries or freezing assets, leaving those accused in limbo and often unable to defend themselves. From there, the government will often make an offer, a la quote-unquote, take a plea deal and this goes away and you can have your stuff back. If you play ball, you may do the time, pay a fine, and move on. But if you fight like Randall Crater did, all bets are off. You are public enemy number 1, and you'll pay. As you'll hear in a moment, in the recently filed renewed motion for acquittal and motion for a new trial filed by defense attorney Scott P. Lopez, government prosecutors basically ran roughshod with a show trial for political gain. A refresher. Meet the players. You're able to find the diagram we'll describe here at sherloc.substack.com. As we break down the accusations from the Department of Justice and provide evidence to the contrary, this ecosystem chart and following description will help you to keep track of who's who. John Roche, owner and CEO of MyBitcoin Inc., heir to the Disney fortune and longtime friend of Harmony International owner and CEO Bill Donahue. Mr. Roche not only designed and controlled the MyBitcoin website and social media, he advised the government that he indeed owned MyBitcoin. His statements to FINRA, the FBI, and the Postal Inspector tell a conflicting story. Bill Donahue, owner and CEO of Harmony International and longtime friend of MyBitcoin owner and CEO John Roche. In tandem with Roche, Donahue handled the logistics for gold backing MyBitcoin. He also forged documentation on the gold that was supposed to back MyBitcoin and defrauded Randall Crater in the process. Randall Crater, owner and founder of Grayshore Technologies. The government alleges that Crater was the founder and owner of MyBitcoin, yet provided no evidence to actually support the claim. Crater licensed technology and provided technical assistance to Roche and MyBitcoin, and was a minority shareholder in the company. Mr. Crater was also defrauded by Bill Donahue after putting up money for gold. Adam Tracy, lawyer. Tracy reported directly to Roche. Michael Kruger, associate. Kruger advised the FBI on multiple occasions that Roche ran and controlled MyBitcoin and offered to provide extensive documentary evidence. Side note, we did interview Michael Kruger. His interview will be a large part of Part 3 of this expose, but at the end of Part 2, there's a 4-minute audio clip where Mr. Kruger describes his interaction with the FBI and the lengths that they went to try to get him to change his testimony. I will tell you that it is shocking. It will stop you in your tracks, and it is worth a listen. Mark Gillespie, associate. Gillespie also advised the FBI that Roche ran and controlled MyBitcoin. Breaking it down, the statement from the Department of Justice. Let's take a look at the statement from the DOJ, point by point, and the critical information that was left out. From the Department of Justice website, quote, according to documents and evidence presented at trial, Randall Crater, 51, of East Hampton, founded MyBitcoin Pay Inc., MyBitcoin, unquote. Hard stop. First, note the liberal mixing of MyBitcoin and MyBitcoin Pay, two separate entities. This quote-unquote guilt by association tactic is largely done to distract. Roche, by his own admission in a 2015 communication from the Financial Industry Regulatory Authority, FINRA, to the SEC, states that, quote, Roche informed the staff in his interview that he had purchased MyBitcoin software from Crater, who had created and developed it, unquote, and stated and reiterated to the staff that Crater is not associated with the company and has, quote-unquote, no input. Roche further claimed that, quote, everything is under my name, unquote. These statements are supported with statements from Michael Kruger and Mark Gillespie, who assert that Roche stated the same and was in control of all functions. You can see snapshots from the FINRA report at sherloc.substack.com. In reality, Roche had licensed the technology MyBitcoin Pay from Crater via a signed agreement. This is important to note. In a June 2020 interview with FBI Special Agent David Carrilli and Postal Inspector Jan Koska, Roche had a very different recollection of what transpired. In that interview, Roche states that, quote, he did not recall how the pricing of the coin was determined, but believed it was based on supply and demand, unquote. And that, quote, Crater was in control of all of that, unquote. Roche went on to state in the interview that he, quote, had no formal agreements with Crater or anyone else and never personally sold or tried to sell MyBitcoin stock, unquote. And that, quote, the informal agreement was the split of the company 50-50 with Crater. These statements are in conflict with Roche's statements to FINRA, the licensing agreement with Crater, and a failed attempt to sell the company in 2017. Instead of working to document these facts, the CFTC and the federal courts ignored the evidence presented by Crater's counsel and empowered co-defendants who would carry their narrative by keeping them out of the line of fire. From the Department of Justice website, quote, a purported cryptocurrency and virtual payment services company headquartered in Las Vegas, Nevada, offered virtual payment services through a fraudulent digital currency, quote, MyBitcoins, which he marketed to investors between 2014 and 2017 using misrepresentations about the nature and value of coins, unquote. Hard stop. Words matter. 1. The DOJ and CFTC make the statement that MyBitcoins were a fraudulent digital currency. Yet Senior Judge Raya W. Zobel of the U.S. District Court for the District of Massachusetts ruled that MyBitcoin was a commodity in 2018. This ruling is linked at sherloc.substack.com. During the trial, the prosecution then attempted to say that it wasn't a cryptocurrency, and then it was. It's important to note the actual definition of the word commodity. From Webster's Dictionary, 1. An economic good, a product of agriculture or mining, an article of commerce, especially when delivered for shipment, a mass-produced unspecialized product. Number 2, something useful or valid. B, convenience, advantage. 3, a good or service whose wide availability typically leads to smaller profit margins and diminishes the importance of factors such as brand name other than price. 4, one that is subject to ready exchange or exploitation within a market. Please note definitions 2, 3, and 4 for the sake of this case. The question, which one is it, fraudulent or a commodity? Number 2, quote from the DOJ site, a purported cryptocurrency and virtual payment services company, unquote. Hard stop, words still matter. Purported, adjective, appearing or stated to be true, though not necessarily so, alleged. Purport, verb, appear or claim to be or do something, especially falsely, profess. The DOJ and cftc claim that the cryptocurrency and virtual payment services were, in essence, falsely professed as real. Oddly enough, evidence provided by Crater's legal counsel shows screenshots that the app for the service were functioning, and the API, application programming interface, which allows 2 or more computer programs to communicate with each other for the systems, was tested and functioning. Additionally, a video linked at sherloc.substack.com shows the functionality of the system with a MyBigCoin ATM machine. This 3-minute video shows in detail exactly how the MyBigCoin system works, how money is transferred in and out, and the actual wallet on the screen. This is another instance of evidence ignored that refutes government claims of false/misleading statements. The question you may be asking yourself is why, and that's the right question. More from the Department of Justice website. Quote, Crater and his associates falsely claimed that Coins was a fully functioning cryptocurrency backed by $300 million in gold, oil, and other valuable assets. Crater also falsely told investors that MyBigCoin had a partnership with MasterCard and that coins could readily be exchanged for government-backed paper currency or other virtual currency. Crater promulgated these representations through social media, the internet, email, and text messages. In reality, coins were not backed by gold or other valuable assets, did not have a partnership with MasterCard, and were not readily transferable. Hard stop. We have established that the coins were a functioning cryptocurrency, and through leaked documents from whistleblowers and interviews with people close to the investigation, we've discovered that Bill Donahue forged documents related to the gold assets. You can see the email where Donahue actually forged, the letter, and then the full list of documentation, including record of the gold and proof of insurance buying the gold, all linked at sherloc.substack.com. It turns out that Donahue represented that he and John Roche had rights to commit Gilman Metals owner Richard Galvin's gold to back MyBigCoin. Details from the motion for acquittal. The government failed to prove that Mr. Crater acted with the specific intent to defraud. The government's case rested on 2 fundamentally flawed allegations. 1, Mr. Crater willfully participated in a scheme to defraud, and 2, that Mr. Crater did so with the requisite specific intent to defraud. Even a review of the evidence in light of the most favorable to the government demonstrates that the government failed to prove either of these facts. Indeed, the government's presentation of proof was notable for its failure to show that anyone associated with Mr. Crater believed or indicated that they knew they were participating in a scheme to defraud. Moreover, given the numerous communications between Mr. Crater and others, it is noteworthy that the government offered no evidence of a smoking gun communication. Rather, the evidence showed that Mr. Crater was acting in good faith and thus could not have the specific intent to defraud. For example, the government did not prove that Mr. Crater knew for a fact that MyBigCoin was not backed by gold. Rather, it was the defense who presented the evidence that Mr. Crater was misled by William Donahue and John Roche into believing that MyBigCoin was backed by gold. It was the defense's investigation and interview with Mr. Richard Galvin that revealed Mr. Donahue was not authorized to commit Mr. Galvin's gold to MyBigCoin. However, Mr. Kruger did not know this fact when he and others stated that My Big Coin was backed by gold. Indeed, the evidence presented by the defense showed that Mr. Kruger was defrauded. Thus, when he stated to others that My Big Coin was backed by gold, he truly believed this fact to be true, even though it was not. As a result, Mr. Kruger was acting in good faith. Kruger was unaware of this fact. When then discovered that Kruger was defrauded, spending tens of thousands of dollars in legal expenses with Harmony International's law firm. Sadly, evidence of the Donahue fraud was never given the chance to see the light of day either, yet the mention of fake gold was actually part of the closing arguments for the prosecution. As we shared in part 1, the contention was that there was, quote, no partnership with MasterCard, unquote, does not show that there was actually an agreement for MasterCard branded cards through DCR Strategies, TrueCash, and UltraCard. Linked at sherloc.substack.com, you'll find the signed contract with DCR Strategies for TrueCash, the affidavit from a representative of UltraCard Services, and all of the promotional materials showing the My Big Coin card and how it worked from DCR Strategies and TrueCash. So not only were there cards, but witnesses during the trial testified that the cards existed and they worked. From the motion for acquittal. Number 3, the government failed to prove that My Big Coin did not have a relationship with MasterCard. Notwithstanding Mr. Audette's testimony that My Big Coin did not have a quote-unquote partnership with MasterCard, numerous witnesses for the government and defense testified that My Big Coin did issue a debit card with the MasterCard logo on it. Specifically, Mr. Lynch testified that he received a call from Allied Bank with the Legend Preferred Customer and MasterCard on it. Peter Bell testified that he received an UltraCard with the Legend Preferred Customer and MasterCard on it. Jay Bird testified that he received a MasterCard in the mail with the Legend Preferred Customer on it. Tom Callahan testified that he received an UltraCard with the Legend Preferred Customer on it and that he used the card and it worked as intended. Given that this evidence gives equal or nearly equal circumstantial support to a theory of guilt and a theory of innocence, a reasonable jury would necessarily entertain reasonable doubt. If the evidence viewed in light most favorable to the prosecution gives equal or nearly equal circumstantial support to a theory of guilt and a theory of innocence, then a reasonable jury must necessarily entertain a reasonable doubt. To sum it up, the DOJ and the CFTC, in public statements, co-opted a number of things they allege that Randall Kruger did, a la founder of My Big Coin, faked MasterCard deal, lied about the gold, etc., for their own gain in a Bellwether case, but they were unable to provide proof of those claims, nor did those claims help lead to a conviction in the case. As you can see at sherloc.substack.com, in the motion for acquittal, the counts that they managed to produce a conviction on were also suspect. This information on alleged wire fraud and a money service business operation is linked at sherloc.substack.com and includes evidence and closing statements from the government. The final count, lack of proof that My Big Coin was a money transmitting business, is mission critical. As you read it, you'll see that it was unreasonable for a grand jury to not have reasonable doubt. And the count as it stands is very disturbing because it sets the precedence that if you write someone a check, you could very well be prosecuted as an unlicensed money service or money transmitting business. Evidence revisited. 2 key components in the memorandum in support of certain defendants' motion for sanctions. In part 1, we published a sealed memorandum that, if it had been admitted, would have ended the CFTC's entire case. As a point of information, we wanted to revisit this document in more detail. Key number 1, this document first sets the stage for just how badly the government presented its case. In an extraordinary lack of candor in the ex parte filings presented to this court, the CFTC and its attorneys prevented this court from making an informed decision and obtained draconian relief in the form of a crippling asset freeze against the defendants, Kruger et al. Alleging that the virtual currency in this case was not backed by gold, they failed to disclose evidence that it was. Alleging that a credit card tied to the virtual currency in this case did not exist, they failed to disclose their knowledge of a contract establishing such card. Alleging that the reported trading prices of the virtual currency in this case were false and illusionary, they failed to disclose the evidence that the virtual currency's price was in fact determined by trading in the marketplace. Key number 2. It then provides a real-world look at how the government is tone-deaf in understanding that the desire for power and control has real consequences. From the motion. To be blunt, the CFTC's conduct during the ex parte proceeding and the effect of that conduct on the ensuing preliminary injunction is nothing short of attorney misconduct. It is a violation of the Massachusetts Code of Professional Responsibility applicable to all attorneys who practice in the United States District Court for the District of Massachusetts. It is especially concerning because the attorneys who engage in this misconduct represent an agency of the United States. Randall Crater, Erica Crater, Kimberly Renee Begine, and Barbara Crater Meeks, Monvance, request that the CFTC and its attorneys be sanctioned for this fraud on the court. At minimum, the Monvance ask that the fruit of the CFTC's failure to present material evidence to this court at the ex parte proceeding, the entry of this consent preliminary injunction, be vacated. Defendant Randall Crater and his wife, relief defendant Erica Crater, have young children, and Mr. Crater is the family's only source of income. With almost all of his assets frozen, he is funding his own defense and the defense of his mother, sister, and wife, as they have no financial ability to defend themselves. The press reports of the CFTC's allegations have resulted in Mr. Crater and his family members receiving death threats, and they have been stalked and ridiculed on social media, including a campaign of mean and derogatory messages blasted out to the parents of the friends of Crater's children. These are real-life consequences of the government's lack of candor and failure to investigate their suspicions before misleading the court in an ex parte proceeding into granting an asset freeze against him. When combined with the Gomersall deposition information, the case for sanctions is crystal clear. We strongly encourage you to reread the memorandum for context and part 1 of this expose at sherloc.substack.com. In part 3 of our expose, we'll connect the dots with questionable testimony from the IRS, and we'll hear the story of Michael Kruger, a business professional who truly believed that MBC was not only going to help millions of people, but allow him to help others as well. His reward for honesty and talking with the FBI? Threats and intimidation while battling stage 4 cancer. You'll find a sneak preview with our conversation with Michael Kruger at sherloc.substack.com. Do you have a case that's in need of research or an expose? Email us, AskSherloc, that's SHERLOC, AskSherloc at protonmail.com. All inquiries remain confidential. And if you're so moved, please support our work. We have a Give, Send, Go. You'll find the links at sherloc.substack.com. You can also become a paid member of our Substack newsletter and content. Thanks for listening to Sherlock Exposes. I'm R.C. Williams.